रिकॉर्ड चालू हो गया। देखो रिकॉर्डिंग होने शुरू होने के बाद है ना बटन रेड दिखा ना रेड। थोड़ा पीछे हो ना, पीछे
holding accreditations from prestigious institutes such as the Charles Institute of Arbitration, London, and with extensive training from institutes like Utah University, she is actively involved in training and advisory roles from within the legal community. I would now like to request Akansha ma'am to kindly present our esteemed assessor a memento as a token of her gratitude. I would now like the room captains to take over.
Thank you, conveners. Before starting with the final round, we would like to brief the judges about the functioning of this room.
I, Vanshika Billa, will be serving you as room captain 1 and will be assisting you with maintaining the decorum of the court.
And I, Rashya Mishra, will be serving you as room captain 2 and will be assisting you with time moderation.
Further, as mentioned before, there will be 2 room captains present in the court to assist the assessors and will act as facilitators between the assessors and the negotiating team. The judges are requested to please seek our assistance whenever it is required.
As stated in the rule book, the total time for the mediation session will be 90 minutes. Then, 10 minutes will be given to the judges to submit the Phil's quotients. After this, we'll be having a feedback session with the judges. The judges may exercise discretion for extending the time for the mediation session beyond the time specified in the rule book.
The team code for the requesting party is MT9 and the team code for the responding party is MT17. And the team code for the mediators are MD17 and MD9. I would now like to seek the permission of the judges to start the session.
Yes, please.
Session. I'm very well aware both the parties have travelled a great distance to be present in today's session. So I hope you've been provided with your drinks and refreshments and you're comfortable enough. Yes. Alright, so let's proceed. So first of all, I would just like to say that I'm honoured to be on the same table as the 2 business giants in the textile and the electronics industry. I would like to express my gratitude towards both the parties for selecting us as their mediators. I am Manvi Pahwa and this is my co-mediator Harshita. Both of us are certified mediators with around 10 years of experience in this particular field. We deal with commercial disputes pertaining to textile and electronic industry mainly. So now I would like to request the parties to proceed with their introductory statements and to let the mediators know if they hold any kind of power or authority to take decisions on behalf of their companies. The requesting party may proceed.
Hi, I'm Harv Textiles and my preferred pronouns are she, her. I hold the power to take decision on behalf of my company.
And what name would you like to prefer?
You can call me Dhanvi.
Dhanvi, alright.
Good evening all. I have the privilege to represent as a counsel for Arav Textile, which is a renowned company known for its innovative fabric design. And my name is Anuja Babar and you can refer to me by my first name, Anuja.
Thank you, requesting party. The responding party may proceed.
Good evening everyone. I am Ms. Rose Subramanian, the CEO of Zenith Electronics.
Thank you, parties. So first of all, I would like to take a moment to congratulate both the parties for amicably deciding to resolve their disputes and for being present in today's session. I would really like to commend both the parties for choosing this particular forum over litigation, as litigation might have unnecessarily escalated the entire issue, and on the other hand, mediation is a more expedient, cost-effective and a collaborative approach to actually solve the problem. In addition to that, I would like to say that mediation is a voluntary, confidential and a mutual mechanism for solving any kind of problem. Now, this is an informal session where the parties do not need to necessarily agree with any settlement that they are not ready for or they are not comfortable with. So one thing we should understand is that our paychecks are not contingent on the fact that we should find a resolution and a solution right now in today's session, so we can take our time, and this is a completely voluntary procedure. In addition to that, this is completely confidential too, meaning anything that is being discussed here in today's session will not go beyond these walls, and the information will not be released in the outside world. So the parties must be as open and as honest as they want to be. In addition to that, I would like the parties to understand that mediation is very similar to the process of driving a car, wherein both the parties are like the drivers of the car steering the wheel, and us as mediators, we are present here just in the capacity of a GPS, or you might say a navigator, to ensure that the entire process runs smoothly and you are able to reach your ultimate location. So, as mediators, our role is to facilitate this entire process. And for doing the same, we will be intervening, we will be asking questions from both the parties with an intention to navigate this entire session towards a mutual settlement. Now, in addition to that, we as mediators, we are not present over here to judge any of the parties, and we won't be making any kind of legal comment or a remark, and will remain neutral throughout the process. One thing I would like to highlight to both the parties is that if you do see me and my co-mediator taking down some notes or writing something down during the entire session, that is solely for the purpose of facilitating this entire session smoothly, and in addition to that, these notes will be shredded right after the session in order to maintain the confidentiality clause that I've talked about prior. So is that clear, parties?
Yes.
Alright, so I would like to ask one question from both the parties. Is this the first time that they are attending a mediation session regarding this issue?
Yes.
Alright, so no worries. As mediators, it is our role and responsibility to run you down through the entire process that will be followed today, and some ground rules that ought to be followed. So that will be covered by my co-mediator. Over to you, Harshita.
Thank you so much, Manya, for wonderfully explaining the mediation process and the role of mediators. And initially, I would like to extend my heartiest appreciation to both the parties for resorting to mediation as a process to settle your dispute. So before we delve into any business or intricacies of mediation, one thing that I would like the parties, which is very prominent, is to sign the confidentiality agreement, both the parties. Also, with that, you are provided with the handbooks. Though my co-mediator and I will be explaining and helping you throughout the mediation process, but keep your mediation books handy so that in any time you feel or you need to refer it, you can go through it. So parties, we now, as my co-mediator wonderfully explained what the role of mediator will be. As she has told, we will be acting as a neutral party, we won't be judging you. Additionally, other than that, what becomes important for you parties to understand that this mediation process serves, like going with a simple analogy, it's just like a mining. The more information you put for or the more resources you look for, the better is the understanding of this process. So parties, feel free to share whatever you can at this point of time, right? Because then only we would be able to understand each other's position. So parties, it's also very important for you to understand that how this mediation process will go forward, what will be the structure. We'll start with the opening statement from the requesting party, followed by the responding party. In opening statement, we want that both the parties let each other know that what your current position looks like and what state you are. So additionally, other than that, we will, after the closing statement, we'll proceed with the agenda. Basically, what agenda will be are the issues that you want to discuss on this table. Issues, and we will be taking that issues in the way you want, in the order you want. With that, we'll move to a joint conference where we will have some conversation regarding what business at hand we have. With that, there's also a provision of private caucus, which is very important for the parties to understand.
Private caucus is basically a session where at any point of time the parties feel that something is not going according to their need, or the parties want to discuss anything with mediators privately. They can call for private caucus. However, when the mediators feel at any point of time that there is a need for a private caucus and there is a situation of deadlock or impasse, we will call for the private caucus. Then we'll resume the joint session, and post that we'll have the closing statement. I hope the parties are clear with the procedure that how we'll move forward. So now I would like to tell you some basic ground rules that both the parties must adhere during the session. That parties should avoid using any offensive language. Parties were requested to be receptive towards each other. Try not to interrupt while the other party is speaking. And one thing, if the parties can confirm, because it becomes very important, that we have not met them before, and so that it ensures that we do not have any vested personal interest in this session. Right, parties? Yes. I hope you are fine.
Yes.
Then this floor is open to you. We'll be starting with the opening statement. Go ahead. Let's try to come with an amenable solution so that everybody can go ahead with win-win situation over here.
One thing I'd like to add is, in today's session, we are here to reach a middle ground. And in order to reach middle ground, we need to speak as well as we need to listen. So let's open our ears and as well as our mouths so that we can speak and we can listen efficiently. And let's maintain the mutual respect towards each other. That is the basic of a mediation process. We'll respect you, you respect us, you respect each other. I think we'll definitely be able to reach an amicable solution.
And also, just to comfort parties, if at any point of time you need any kind of refreshments, we do have a provision for that as well. So make sure you're comfortable. If you need a break, you can ask for a break as well. So parties, requesting party, we will go with the client, proceeding by the counsel. Go ahead.
Sorry to interrupt you, Madam Mediator. As you have discussed that mediation is a private procedure and the confidential will be preserved, I see a camera in this room and I really hope that it will not violate the confidentiality.
Yes, so we truly understand your concern. These cameras just for some photography purpose and nothing would be revealed. When my co-mediator told you that nothing would go out of this wall, please trust it. We'll ensure that this process is completely fair and nothing is out of the
These recordings are also as confidential as our notes, so don't worry, everything will be taken care of. So, as my co-mediator said, requesting party, please proceed with your opening statements.
Thank you so much, parties.
Greetings to everyone present here. It is very good to see you all on a sunny Thursday evening. Even though my counsel, Ms. Anuja, has briefed me on this process, I would like to offer my heartfelt gratitude to the mediators for so succinctly explaining the ground rules of mediation and making us so comfortable in this setup. The example Madam Mediator gave about us being drivers in this setup where they are the GPS and they are going to navigate us is indeed true, and we're really looking forward to it. I know this is a very commercial matter, but since we are here in a collaborative approach with a flexible and open mind, I would like to begin by thanking Zenith Electronics at first for being here today. We really appreciate you coming here with a flexible and open mind to discuss the disputes that are happening between us. We, along with a sincere commitment to resolve the disputes through constructive dialogue and negotiation, and with the spirit of compromise, we are hoping that we reach an amicable solution today. So I would like to start by talking a bit about myself and where I come from. So I am Dhanvi, the CEO of Arav Textiles. Arav Textiles is not only a company for me, it is like my baby. I have deeply invested my heart and soul in this company. The story of our journey is not only about business transactions or contractual obligations. It is much more than that. It is a tale of passion, dedication, and a relentless pursuit of excellence. Arav Textiles has taken immense pleasure in and pride about its innovative fabric designs, along with a rich history of textile craftsmanship, creating a brand which is synonymous with innovation as well as reliability. Our legacy, which dates back to over a century, speaks volumes of our pursuit for excellence as well as our unwavering dedication. Allow me to extend my heartfelt gratitude to Zenith Electronics, a beacon of innovation in this technological sphere. With its cutting-edge technology and reliable products, they have definitely carved out an exceptional reputation for themselves. It is an honor to stand alongside such visionary leaders, and we are grateful for the opportunity to collaborate with Zenith Electronics on a project of mutual significance. With the same hope in our hearts and the excitement and the optimism for a groundbreaking potential collaboration, we entered into agreement with Zenith Electronics in January 2022. We poured our sweat, tears and countless hours of hard work into the vision of revolutionizing the textile industry with our smart fabrics. However, over time we did realize that our expectations were not fulfilled. So just pointing out what position we are in and what we have been going through, I think it is very important to go ahead with this mediation session today. The delays in the product development and the looming market launch, along with the performance inconsistencies, have resulted in substantial financial setbacks, impacting our bottom line and have jeopardized our financial stability. Secondly, with regards to our reputation for innovation and reliability, which is very well set in the market, it has actually been tarnished as a result of these delays and uncertainties regarding the launch of our fabric line. Also, the missed market launch deadlines have resulted in missed opportunities and potential revenue losses for the...
Mind the same conclusively, we look at the case of BSNL versus Reliance Communication, wherein the court devised a three-pronged test to evaluate and to determine the nature of the clause of the liquidated damages. Herein, the first criteria which they use is the difficulty to evaluate the precise amount which can be ascertained as the loss occurred. The court, as in construction contracts, it is often very difficult to evaluate what the loss may occur or may not occur after a certain structure is built. This test to determine whether the amount is a penalty will fail. Secondly, in the three-pronged test, the meaning of the clause while the contract was entered into. While the contract was entered into, both the parties had mutually agreed upon the stipulated amount of liquidated damages to be a genuine pre-estimate of the loss. Hence, this criteria to establish it as a penalty will also fail. The third point gives weightage to what is actually given in the contract. Since in the contract it is clearly mentioned that the clause is a genuine pre-estimate of the loss which may be incurred, we can apply the facts of this case to the test and establish conclusively and state that the liquidated damages clause is a genuine pre-estimate of the loss incurred and is not in the nature of a penalty. Moving on to the second part of the issue, if the respondents are entitled to retain the bank guarantee or not. The bank guarantee was submitted to them as it is a common practice in construction contracts to submit a certain amount as security for a smooth performance of the contract. The main issue herein arises the presence of a forfeiture clause. In our contract, there is no forfeiture clause. The forfeiture clause, the vital issue in such contracts is the presence or absence of such forfeiture clause. This forfeiture clause allows the security to be forfeited in favor of the aggrieved party. As observed in Suresh Kumar Wadhwa versus State of MP by the Supreme Court, that in case of absence of a forfeiture clause in the contract, no right to forfeiture is available. Hence, under no circumstance should the respondents be entitled to the bank guarantee deposited by the claimants. The Indian courts in PV Pallai versus State of Kerala established that the first and foremost thing in a case of an alleged breach of contract is the determination as to who is the aggrieved party and who caused the delay. The respondents have deemed themselves as the aggrieved party without any deliberation into the fact as to who caused the delay and retained the bank guarantee. Moving on, in Variety Body Builders versus Union of India, it can be observed through this case that the courts are inclined to order the return of security deposit if actual loss is not proved. In our case, not only actual loss is not proved, there is no right to forfeiture which exists. Hence, there is no right for them to retain the bank guarantee which was submitted on behalf of the claimants as a security to the respondents. Recently, in a very similar case, Devachand Construction versus Union of India, the arbitrary tribunal not only ordered the return of the security deposit, but did so within 6% interest. The court had relied upon Fateh Chand versus Balkishan Das. In all three cases, Devachand Construction versus Union of India, Fateh Fateh Chand versus Balkishan Das, and in our situation, the claim of liquidated damages arose merely from contractual obligations, without the presence of any actual proof. As the counsel for the claimants, I pray that the tribunal is kind enough in ordering and first of all declaring that the claimants were not in breach of the environmental guidelines according to issue 2. The respondents were accountable for the delay caused in the completion of the project. Order that the claimants are granted compensation and prolongation costs, and that the respondents return the bank guarantee as there is absence of a forfeiture clause. And we also pray that the tribunal pass any order that it may deem fit in favor of the claimants. Thank you to the tribunal.
Now I would like the respondent side to start with their answers.
Greetings to the respected members of that is Valorian Gas and Oil Company in the present matter before this tribunal. For the time period of 15 minutes, I shall be dealing with two issues. In first issue, our contention would be to support the argument that the change in specification is a fundamental that the change in specification is not a fundamental change, and also the delay is attributable to the claimant. And in second issue, our preliminary question, counsel seek permission to move forward with the further submission of my first issue. Members of the tribunal, I would like to highlight the complexity of the construction industry, where it is very uncertain and unpredictable that what members of the tribunal, I would like to draw your kind attention to the page 2 of the relevant contract, clause 4. If members of the tribunal allow, I would like to quote unquote the line. The contractor agrees that the requirement given in drawing specification of the contract are minimum requirement and are in no way exhaustive and guaranteed by the company. By agreeing to this clause, it shows that the contractor was aware that these were the minimum requirements and no contract works in the bare minimum. The counsel would like to highlight the case of Turner Construction Company versus United States, in which the court ruled that the company had the right to modify and alter the terms of the contract when it is necessary and justified. The inherent unpredictability of the situation justify the changes as long as they are necessary, valid and justified. Members of the tribunal, this brings to our first contention that the change made by the company is just a mere variation, not a fundamental change. Members, variation refers to a minor change in the specification of the unit that do not alter the essence part of the contract, whereas fundamental change refers to the profound alteration that significantly alters the terms of the contract. And here our contention is clear that it is written that it shall be the responsibility of the contractor to meet all the requirements and design criteria contained in the contract. And
law firm and what the law firm is capable of. Then after that you have come on the case pro bono, just because the social activity, what about the expenses, who are going to take care of? In these kind of case, the kind of problem he is in, there are multiple cases against her. Police and state government is after her life. Surely he will not get or she will not get justice. In the local area, what you need to do to get those cases transferred, because nobody has talked about here about right to fair trial. Right to fair trial is also a constitutional right. Then right to privacy is there. Right to privacy, partially, they were amended or overruled partially. Right to privacy, Kuthu Swami case is landmark there, which is 9 judges bench, 2017. Yes. After that, she has tried to tell you each and everything in her own way. Moreover, आओगे क्या? मतलब problem मुझे नहीं है. If she is earning from that activism, then it's okay. So petition habeas corpus.
Yes.
How is habeas corpus relevant
Sir,
here?
he was detained without being present.
What is habeas corpus?
So to have the body.
To produce the body.
Yes. Because they were not produced.
habeas corpus यहाँ पे applicable नहीं है. कोई habeas corpus maintainable है. Once he is out of the detention, habeas corpus is not maintainable. There could be other writs. शराब वो भी है, मतलब that's a different thing. Maintenance seek a direction. That's a different thing. And I think I go on and on. ठीक है. फिर moreover आपका जो है your legal analysis and advice, I found it little bit wanting. आपका जो advice आपने जो किया, you have never told कि this kind of what you said will fight pro bono. हमारी मम्मी ये करती थी, हम भी करेंगे, इसलिए I'm attached. No, he's not here for that. She doesn't give a damn. She's not interested about what your mother is doing. She's interested what you are capable of. My father is a doctor. That does not mean me I become a good surgeon. No, I had different set of skill. So you should have point wise. These are your problems. These are whatever your rights have been affected, or so to set things right, what kind of litigation, how many litigations, whether in the High Court, whether in the lower court, how will go about it? You said we'll take care of that. How? You will never do it. You were also at a certain point of time, in a way you have told your problem. It's okay, but how you want it, what you want it, you never set out. And there is some kind of conviction which is matter. Yes, मुझे लड़ना है, मुझे ये नहीं किया. The moment they said pro bono, no, I don't fight pro bono. There are so many cases. Yes, you were right in your own way. So this is my analysis. But none of you have mentioned about the constitutional rights. Articles कौन-कौन से हैं, judgments recent कौन-कौन सी हैं. There are so many judgments.
Thank you so much.
What my private judging of client counseling competition actually, because as an academician in a college we also conduct such client counseling competitions and also judge. See, first of all, it's a first meeting of the client. Let us be very clear. Okay, so here I disagree with the very fact that what does first meeting require? Okay, it's a competition. It is very good that you are talking about certain fundamental rights or certain. She is not a law literate person. Let us understand that. She is not law literate, number one. She doesn't understand certain judgments or their outcomes or this. This is as a client. If I go to a lawyer and who is not a law literate person, something I require very badly is that how things will be taken care. That is only, and what you can do. These are the only two things. Now, where things went wrong, even if the one thing that I found missing was, that you didn't jot it out that you were having this before. Okay. So it is on the spot.
Yes.
So this thing. So she did said that नौकरी चली गई है.
Yes.
मतलब मैंने नहीं सुना.
Warning, yes, they said that.
Warning मिली.
Suspension.
Warning मिली.
Yes, I was suspected.
I was in investigation. I didn't say I was part of it.
She didn't say. She didn't say that she was part.
They said that's notice.
नहीं उसको warning मिला है. उसको warning notice मिला.
Yes.
That doesn't mean that उसकी नौकरी चली गई. You know, you actually read too much in between words. मुझे कई जगह लगा. जैसे
मतलब शी नेवर सेड दैट नौकरी चली गई है, पहली बात। बट ठीक है, वो क्लाइंट है, वो कंफ्यूज है, ऑलरेडी आप भी बोल रहे थे कि कंफ्यूज है। सी फ्रॉम वेयर डिड इट स्टार्टेड, ठीक है, कि देयर आर व्हाट इज इट दैट वेंट रॉन्ग विद हर। आपने बताया, पॉइंट आउट, क्या क्या बताया आपने कि कॉलेज कि आपके स्कूल में इरेगुलरिटीज है ना, तो स्कूल में इरेगुलरिटीज है। फाइनेंशियल आपने पूछा, फाइनेंशियल इरेगुलरिटीज है, कौन सी इरेगुलरिटीज है? एडमिनिस्ट्रेटिव,
स्कूल फंड्स,
स्कूल फंड्स में है, ठीक है, स्कूल फंड्स में। ये कैसे पता चला इन्हें?
राइट।
Being a teacher, I cannot ever know what is going wrong there financially, because please understand, administration and teaching are two different parts in an institute. Why she came to know, or what was that incident she came to know that there are financial irregularities? Regarding whom? कौन कर रहा है financial irregularities?
They mentioned that they fight social injustice.
That is okay. That is a different thing altogether. She is a social activist. That is a different thing. She might be fighting for child marriage. She might be fighting for dowry. She might be fighting for so many things. That is perfectly fine. But इसमें उन्होंने कहा कि जी मेरे ना social irregularity, मेरे ना irregularities हैं। क्या irregularities हैं? कैसे पता चला है?
ये सब कुछ तो आता है।
Number one. ठीक है? वो पता चला, कैसे पता चला, फिर क्या, मतलब ये सारी चीजें ना, एक मुझे नहीं लगा कि कोहेरेंस आई, एज इन व्हाट वाज द ब्रीफ, हाउ इज द ब्रीफ प्रिपेयर्ड बाय अ लॉयर, इज समथिंग दैट स्टार्ट्स फ्रॉम द पॉइंट एंड कम्स एट द एंड विद द रिलीफ गिवन, पॉइंट ब्लैंक रिलीफ। वो इतना स्मॉल भी हो सकता था कि अब आप आरटीआई बोल के पहले ये काम करिए, अब आरटीआई आप डाल नहीं सकते क्योंकि आप ऑलरेडी स्कैनर में हैं, तो ऐसा करते हैं किसी और के नाम से डलवाते हैं, पहले तो केस बनाओगे ना। इसको रिलीफ मिलेगा कैसे? इसको रिलीफ चाहिए, इसे पता ही नहीं इसको क्या चाहिए, ठीक है? लेट अस अंडरस्टैंड दैट वे। नाउ ही इज अ कंफ्यूजिंग, बिकॉज वो उनका भी पार्ट है, क्योंकि ही और शी जो भी है क्लाइंट है, उनको जज किया जा रहा है कि भाई आप इनसे इंफॉर्मेशन कैसे निकाल रहे हो, ये जो है वो क्या कर रहे हैं, छुपा रहे हैं इंफॉर्मेशन। ही इज नॉट वेरी कंफर्टेबल, लेट अस अंडरस्टैंड। पहली बार मिल रहे हैं तो इंफॉर्मेशन आपको निकालनी है। अब इंफॉर्मेशन जब जैसे उन्होंने बोला फाइनेंशियल इरेगुलरिटीज, तो आपको कैसे पता चला? आपको टीचिंग में कौन सी फाइनेंशियल इरेगुलरिटीज, ठीक है, लेट अस से, है ना, सी मेनी थिंग्स में बी हर अजम्पशंस, शी माइट आस्क फॉर एनीथिंग। आपका केस स्ट्रांग है, आप वो हैं, बट मुझे तो केस ही नहीं समझ में आया कि केस क्या है। लेट मी बी वेरी फ्रैंक, मुझे केस, अगर आप मुझे रेमेडी, हम सुप्रीम कोर्ट चले जाएंगे और सुप्रीम कोर्ट से हम रिट ले लेंगे, दिस इज नॉट द as far as a teach, because I teach CRPC, I teach criminal law, been teaching for last 20 years. पुलिस आपको तंग कर रही है, ठीक है, अब पुलिस तंग कर रही है, कैसे इनको कस्टडी में लेके ना पूछताछ के लिए बुला रही है। अच्छा, what is the remedy that you are going to give? Can you answer that?
But it is negligence by the police, I guess.
Negligence?
Yes.
क्यों?
पुलिस
10 बार बुला ले?
But they must have a strong ground for that.
अरे नहीं, बिल्कुल नहीं। रेमेडी कहाँ है इसमें? क्या करोगे? अच्छा बताओ, पुलिस का पास क्या, पुलिस क्यों बुला रही है? आपने पूछा इनसे क्यों बुला रही है, क्या पूछताछ कर रही है?
उनके जो केस था, इनका कि ये प्रोटेस्ट कर रहे थे,
5-6 लोग प्रोटेस्ट कर रहे थे ऑन द डाउटफुल, पुलिस पकड़ के लेती है। देयर इज अ सेपरेट प्रोविजन इन सीआरपीसी स्टार्टिंग फ्रॉम सेक्शन 133 ऑनवर्ड्स, डिस्पर्सल ऑफ अनलॉफुल असेंबली। डिस्पर्स कर दिया अनलॉफुल असेंबली में, एग्जीक्यूटिव ऑर्डर है, आपने अरेस्ट कर लिया, अनलॉफुल असेंबली डिस्पर्स हो गई, अब काहे की पूछताछ? किस चीज की पूछताछ? अनलॉफुल असेंबली डिस्पर्स हो गई, पकड़ के ले गए लोग बाग, अब क्या पूछताछ? छोड़ा कैसे इन्हें? अच्छा चलो पकड़ के ले गए, छोड़ा कैसे? बेल दी थी, बेल दी थी। आपको पूछना था ना। देखो, पूछताछ करने के लिए पुलिस वाले बुला सकते हैं, 4-5 घंटे या 10 घंटे बिठा सकते हैं और 10 बार बुला सकते हैं। लेट मी बी वेरी फ्रैंक, ठीक है? तो ये ना मतलब कोई राइट जनरेट नहीं करता, लेकिन वो ऑफेंस क्या है जिसके लिए बुला रही है, ये प्रॉब्लमैटिक है। किस चीज के लिए बुला रहे हैं उसको? ऑफेंस क्या है? आर यू गेटिंग माई पॉइंट और नॉट? केस रजिस्टर हुआ है क्या? पूछा आपने, है ना? केस कितने लोग थे आपने पूछा? 5 लोग थे क्या?
They said 5-6 people.
5-6 पीपल थे, आपने पूछ लिया, पूछा आपने, इससे कुछ बोला?
Yes.
ठीक है, उठा के ले गए, कितनी देर बाद छोड़ा? केस रजिस्टर किया था क्या या वैसे ही छोड़ दिया?
6 to 7 hours.
यानी केस रजिस्टर नहीं हुआ?
No, 6 to 7 hours was for उनको बुला के बिठाया।
वो बाद में करा।
Right. 24 hours. Yes.
हाँ ठीक है, वो जैसे सर ने कहा हिबियस कॉर्पस तो यहाँ लगेगी नहीं, आपने कहा जी हिबियस कॉर्पस हम फाइल कर देंगे,
You are on that.
है ना? तो हिबियस कॉर्पस तो सामने बैठा है इंसान आपके,
Right.
है ना? 24 घंटे में रखा ही है वो, अब आप कॉम्पनसेशन क्लेम कर सकते हैं फॉर द रॉन्गफुल डिटेंशन बाय द स्टेट।
Agree upon the payment to that particular bank account, we can definitely overlook that. We can, I would let's say let bygones be bygones. We are here to look at the perspective of our relations at the future aspect. And as you have mentioned about the public relations, not being crystallized until unless the discussion over the payments is decided, we do think we would really like to introspect on that aspect. And with respect to the mentioning about the all other models that my council has mentioned about, separate from being ARGO, there was this also, I would like to say, we perceived at Sensory Node, at Vision Sync X, that Sensory Node is going through this financial crunch, and there was a lapse of 1 month in reinstation of a different account manager for our account. We did believe that, there was a lot of account details. That mail was sent in a hurry. So our assumption at Vision Sync X was that mail was, a particularly sample way that was drafted, and there were discrepancies in the text because it was sent in such a hurry. With respect to the R4 models being stated, that was also one of the credentials that we also deal with you with in other 3 other models. So that was also a plausible belief, and I would say one thing that we did give a leeway to. And that is why these discrepancies were sort of rather put aside by us, because as I have mentioned before, that ensuring the continuity of the operations of Sensory Node, especially when the Sensory Node was facing such a financial crunch, we did not want to stop or have a halt in this process that has been already initiated. And Mr. Aditya must have said something.
See, that was a trust and belief upon which we put emphasis on. That's why we made the payment such a promptly way. And let's forget the past. Okay, this negotiation is all about discussing the future, the present. So let's come to the main agenda regarding the payment. Here we have an offer that we will be providing you an in-kind compensation. Additionally, revenue sharing with 2%. Now, what we mean by revenue sharing, that whatever the revenue we will be earning by selling the products in which your technology, your sensors are used, 2% of the sale would be given to you. A very important thing that there would be a new contract. It would be contingent on performance based, the maximum period of which would be 2 years. I hope you will be
And also to add to Mr. Aditya, we have sort of given to the demands that you have put forward at this negotiating table, because we do believe in prospectivity. And public relations, as you have so elucidated upon how it's really contingent to payment discussion being done and dealt with. We do think once we settle upon this payment term, we do hold this joint public conference which we have a consensus over. And with respect to that public conference as well, we do have certain specifics to mention. And as you have so kindly offered us the venue of your choice for this public conference, which we are really grateful to have at this particular aspect. Payment, as we have mentioned before, being a performance contingent, to use the legal terms my counsel so elaborately uses, is something that we would like to ensure so that such unforeseeable circumstances, such uncertainties, they do not creep up again. And with respect to this aspect, I don't think Mr. Aditya also has to add something.
An important addition to the offer that we would request you to put an acknowledgement system that whoever will be appointed as the next account manager, even the current account manager or any important employee, his contact details must be shared to us to avoid any potential loss or unfortunate event. Secondly, I would just like to say that the acceptance must be given to every communication, not only the payment, every communication. That is, we will build a process. We will be asking you for an order, and then you would be replying to us. Then we would be sending a receipt upon which we would be writing the account number, and you would be accepting that. Only then the payment will be made. So that's important for transparency, more clarity.
Yeah, just to ensure that in the future this discrepancy doesn't happen, and we would like to also highlight here that the amount that we have transferred to that particular bank, it's a huge amount. It has placed a lot of financial crunch even on us. I mean, we do not want to rather say this, but it has sort of jeopardized our relations with our stakeholders. And that is why we were so keen upon having a joint public conference to ensure that this discussion, this entire clearing the air happens as soon as possible. Payment is definitely a really crucial aspect. I mean, this is the crux of the issue that has brought us to this negotiating table, and we do not want to deprive of that particular aspect. But we are flexible, but just in case after the payment happens and we agree on this particular aspect, we put this out to the public. We do give them this declaration that everything is well between both the entities, and the stakeholders can rest be assured that there is no hostility or animosity in the air.
The payment which we made, it was not from our pocket. It was the process and hard work of the employees. It was the money which was invested by the investors due to the faith. One additional point that both the companies belong to a similar sector. Any harm on our reputation would also be in harm on your reputation. If our investors are going, your investors would also be going, because the names are connected, right? Please have the mic.
Surely, thank you first of all, Ms. Mansi and Council. We really appreciate your offer. However, we would like to give a counter offer if that's okay with you. So, see, as I stated that we fulfilled a substantial order of 1,200,000 sensors. And we should get the rightful compensation for the same. So our offer to you is that we can give you a time extension. We can give you a time extension of 30 days. Today is 21st March. The payment for the first half of the order, you can give it to us till 21st April, and the second half of the order 21st May, if that's okay with the other side.
Yeah, thank you so much for that counter offer. That does really show the negotiating spirit on your part. When I would like to clarify why we put forward as the offer of in-kind compensation, this revenue sharing arrangement that we have offered you with. When you mention about losing this amount, this payment over this huge order of 1.2 million sensors, which comes about to something around 3.8 USD crores, I would also like to millions. Yes, sorry, extremely sorry in that aspect. But with respect to that, I would also like to highlight that we have made that payment to a different account as well. We do not hold that money right now, and the search is definitely there for the imposter, and we are really concerned about the aspect of paying you back. That money really does belong to Sensory Node at this aspect. But the financial crunch that both the entities is facing, I think you would agree on this aspect. I mean, you would also relate to this, that this amount is not a really small amount. This is a hefty sum, and with respect to the payment being made to a different account, that is why we proposed an offer and in-kind compensation, so that the partnership in the future keeps on. It will provide a very dual purpose to both the entities. It will meet the immediate needs that Sensory Node has at this present time, and also it would ensure that our future relations continue with no animosity. I mean, as we have really stated so many times before, that public relations is a crucial aspect, and you have also agreed upon this. The immediate need, how it would be satisfied by this in-kind compensation. So the sensors that Sensory Node supplies us with, they are world class. They are innovative, they are exceptional in their own kind. And we believe, we are deciding to launch a different product into the market. So we provide the customers with optical solutions, as Sensory Node must be aware of. So we were providing for that. We would integrate these sensors that would be supplied by you in a new product line that will be traffic sign recognition systems. So that would further enhance the services that Sensory Node and Vision Sync X together provides to the customers, as it would provide them exceptional performance of that, and timely reminders about traffic signs or any camera being attached to the traffic light. So that would ensure two needs at this aspect. It would provide you with immediate relief, as these sensors would be out in the market in a short duration, as you mentioned, probably 15 days. And with respect to the sale of these sensors, I mean, we enjoy credibility in the market. We are known for our innovations. The sale of these sensors can then further compensate the loss that has been dealt by both the parties. So in this particular, we would definitely price these sensors at a higher cap, and further divide the profits between both the entities until the time our issue over the payment being received back from this false bank account that it was submitted to. And So this was our discussion about the in-kind compensation. I would like Sarah to summarize it further.
Thank you. Former American President Donald J. Trump has quoted that if you are going to thinking anyway, think big. Why to constrain yourself to a tier 2 business when you have a chance to go far and reach heights? We are providing you a vision, we are providing you a future, we are providing you a prospect. We are planning expansion and we want to collaborate with you. For a shorter period, for a longer period, that's something negotiable. Just putting more light on what traffic sign recognition system is, that we would be using your sensors into the cameras to detect and interpret traffic signs and road markings. How this would be helping you? Try to see the big picture. Your name would be in the public reputation. More and more people would invest in you. Your compensation would be met. All your losses would be met. Simply. I hope that
that would also further enhance the competitive edge that sensory node enjoys in the market. The capability that sensory node enjoys, it would further be enhanced with this long-term strategic partnership here. So it would definitely provide you with that immediate relief when it comes to the financial aspect, and also ensuring that our future relations are sustained for future as well. And that would definitely as well put out a message in the market and in the public that everything is well between both the entities. There's collaborative spirit at both sides, and that is why we were really contemplating about in-kind compensation as being one. We do recognize the concerns that you have presented here, and we would really like you to contemplate about it.
Surely, Ms. Mansi and Council, we do understand your point and the position you're coming from. However, as you mentioned, that this is a hefty amount. So it also took our resources to make those number of sensors. We have to pay our employees as well. We have to maintain our offices as well. We have spent our resources for the making of these sensors. So we believe that we shall get the compensation for that. We recognize the fact that you are also going through some financial constraints. We can give you a leverage in the payment of these sensors. We can give you 4 installments for that. Moreover, the point that you said that you are willing to buy our sensors for your traffic project, it is an honor for us to engage with you in future business interactions. However, this particular one is also very important for our company, and we believe that we shall get the rightful compensation for them. If you are willing to engage with us in future business interactions, we will also be wanting to help you out in the same. And as a token of gratitude for the other party, if the other party agrees to this offer and to resolve this problem that is at our hand in this negotiation session, we will be more than happy to provide free of cost 500 sensors in the next order of up to 100,000 sensors that your company orders from us.
So what just my client just said, I'll try to be realistic here, guys. I have my duty to be honest with my client and also in an advisory capacity. You do have a plan, and I accept that it is a wonderful plan to plan it out, and we are honored to have you with us on this board. But you also have to see that you plot yourself that a reputation of both the companies on the line, right? 15 days and you are selling that out to the public, right? The traffic police rights. Now to say that I don't think it would work out eventually, because we have to see that both the companies in a financial crunch. You also giving us that opportunity, yes, it would help us financially, but you also have to see 3.84 million is not a small amount to recover. You are saying that we also provide you even more sensors. You also have to see that the future prospect is deemed to be a future prospect until it happens. Yes, the quotes were amazing. I'm glad we are motivated by it. But you also have to see the both companies' reputation is on the edge of this particular negotiation session. We also have to see that, as you said, the both companies are in a financial crunch. We don't know how many sensors that we will be able to sell in 15 days, and also how many sensors we could also. So I advise my client. He has made some offers to retaliate with that. Over to my client.
I agree with my counsel, and earlier the revenue sharing model that you mentioned, that will not be feasible for our company, because that is a subjective thing. As my counsel stated, this amount is a very big amount, and for us to recover that through this possible engagement will not be feasible for us. So what I offered you, I believe is a great offer, and the other party should consider it. It is in the best interest of both the parties, and I feel that this is a workable solution.
But my counsel has said, I'm so sorry for taking this time. We are indeed in a risky position right now. We should not take such big steps which we don't know what the future would lie in our plan. We should take this by small steps. We are indeed and you are a very important client to us, and we are hoping to continue this relationship. But what you are saying is a very big plan indeed. To have those financial resources right now, I don't think we could gather it right now from our company's end as well as yours. Your phishing scam, you said that it will take time to recover that money. You don't have the financial resources to launch that in 15 days. We don't know how much we can sell of that, and also we are not in any position to make more sensors than the amount that is spending to us of $3.84 million.
I agree with what my counsel just said. We are going through some financial troubles right now, and we do not have sufficient funds to make further more sensors without getting the compensation of the sensors already provided by our company. So if that is what something the other party agrees to pay for, we can surely collaborate in future. It is a sincere hope to engage with in your company. It has been an honor over the past 3 years to engage in a business interaction with your company. Definitely both of our reputations have had a good impression on the general public, and it has been a great honor for us. Your company has helped us in a lot of ways, and we wish to collaborate with you in the future. But however, this matter which is at our hand is also very, very important at this point.